And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Good morning and welcome to The Law Show here on CIL 650. Nice to have you along with us. On the program today, we're focusing on estate law and estate planning. And with us back in studio are John Lakes and John White from Lakes White, LLP, a North Vancouver law firm specializing in estate planning and estate litigation. And today, we're going to talk about undue influence. John Lakes and John White, welcome back. Good to see you both.
Thank you.
John Lakes, let's start with you. Let's talk a little bit about Lakes White before we get into the fascinating subject of undue influence. I am so looking forward to this conversation. But tell us a little bit about your North Shore law firm, you North Shore guys, both of you.
Yes, I went to Delbrook High School, the same high school that produced Margaret Trudeau and Pia Chandel and Karen Magnuson, but I wasn't of that same league, so... But the school doesn't exist anymore, but I've lived in North Van most of my life. I've been practicing in North Van since 1981, where our office is only 2 blocks away from my original place of work, which is Oasis Car Wash. So
for goodness sake.
I haven't moved very far, but had my own practice since 1986, and it's evolved into various capacities. And John's been with us since 1999, and we're now known as Lakes White. And we deal with people primarily living on the North Shores, Sunshine Coast, Squamish, North Burnaby.
Right.
And we deal with middle-class people with middle-class issues, and, you know, many of the people we've known our lives. And as part of an important segment of assisting them as we deal with wills, estates, powers of attorneys, and things like that.
Right. So, now, John, lawyers, we have come to know wear the title barrister and solicitor, or both in many cases. You, John Lakes, would be the solicitor of this duo, given that you spend most of your time in the office doing the administrative end of the law. And John White, you would be the barrister, because you go to court more frequently than John Lakes. Am I right with the definition so far?
That's correct.
So far, so good.
Oh,
That's
okay.
right.
Maybe I better stop while I'm ahead of the game. Now, you're a North Shore guy, too, with the exception here being you took a bit of a hiatus from British Columbia, went to law school in Ontario.
That's correct. I went to the University of Toronto for 3 years. Had a great time out there. It's a lovely city. They got a great baseball team, but it wasn't a difficult decision for me to hop in the car the same morning I handed in my last paper and start the drive back to Vancouver.
Right.
I had no intention of staying in Toronto. I wanted to live in Vancouver, and I practiced downtown for about 7 years, and then I moved my practice over to the North Shore in 1999. I've been there ever since.
Right. And you chose, as a young lawyer, to do the court route. You do more court work than your partner, and that's by design and by choice. So what's the attraction? What's the fascination with going to court? Is it the adrenaline?
There's always an adrenaline rush, and as long as there is an adrenaline rush, I'm going to want to do that. It's a performance.
Right.
You have to be at least a little bit of an actor in court. You need to be able to speak. You need to be able to speak clearly and distinctly. You need to be able to speak with conviction so that the judge hopefully is persuaded by what you have to say.
Okay. And John Lakes, most cases, though, don't involve going to court, although a lot of them are assisted by the threat of going to court in out-of-court settlements, aren't they?
well, my goal is to try to keep my clients out of court. So we try to do proper planning, proper agreements, proper documents, so it's clear and there's no court issue. Most files are not like that, but sometimes things blow up, and the important thing is, even though if people have to start a litigation process, most things are getting resolved before they get to court. And
right.
John, so with our office, it gets to a point where a file is at some point where all of a sudden it looks like things are beginning to blow up. So it goes from my desk to John's desk, but just because it's on John's desk doesn't mean it's going to be resolved by a judge.
Right. Gentlemen, we're going to talk about undue influence on this episode of The Law Show, but just before we get into the nuts and bolts of this particular aspect of wills and estates law, John White, what do most people end up in court for? What went wrong? What is usually the main reason for that family feud in front of a judge?
Well, I suppose the answer is that it is somebody's perception that they were not treated fairly.
Okay.
Somewhere in the past, and whether that's because they weren't left anything in the will or weren't left as much as their brothers and sisters were left,
right,
or whether it's because of some family event that took place 20 or 30 years ago, leading to some sort of an estrangement. At the core of so many of these disputes is this sense that rightly or wrongly, someone hasn't been treated fairly.
As opposed, John Lakes, to going to court because the paperwork wasn't done properly. That's something that likely would be resolved in one form or another long before trial, wouldn't
Well, not necessarily, because that's sometimes the problem with estate litigation is the original document wasn't done properly, and so either the judge has to interpret what was meant to be said,
right,
or else because it's so poorly prepared or poorly thought of, the only way there can be a resolution if a judge decides, because you could have 2 or 3 parties who have totally different points of view of what the document means.
Sure.
So my job is to try to have my document clear, that people can understand what's been decided, the person's done it with proper thought. Because the problem is, if it goes wrong, I have to be called to court as a witness.
Sure.
And it's not very... I've been a witness 3 times. In all 3 cases, my will stood up, thank God. But it's not fun having to answer questions not only from the lawyers, but to the judge sometimes, too.
Right.
So my goal is not to be a witness if I don't have to.
So get it done right the first time and try as best you possibly can to set your estate, John White, up in such a way that these fights aren't necessary, that it's all pretty lucid, it's pretty clear, and pretty easy for everyone to interpret and understand.
Well, clarity is hugely important. I mean, if a will is unclear, as John says, it's possible to wind up in court just to ask the court to interpret
Sure.
what the will says, even if the parties are otherwise friendly with each other. There could be competing interpretations of what a will says. You know, as an example, I remember doing one case where the will left some property to all of the testator's nephews and nieces, and the question was, well, is that just his nephews and nieces, or is that also his wife's nephews and nieces?
Oh, it was ambiguous.
It was ambiguous. We went to court over that.
Okay.
And my role was to act for the executor of the estate, where we didn't care what the outcome was.
But you needed some clarification.
We just needed an outcome.
Sure.
And so, those are the most gentlemanly trials imaginable, because everybody is so polite and nobody's really fighting with each other, and it's a point of law, really, or a point of interpretation.
And the other extreme of that pendulum swing, John White, would be a pretty acrimonious, just to be kind about it, scenario in a courtroom where everybody hates everybody.
Well, those happen as well.
I'm sure they do. And pretty colorful stuff, too. The subject of the program today, friends, is undue influence. This is a huge category in law, especially in wills and estates law. So let's start off with John Lakes. Take the lead on this.
Well,
what does undue influence mean?
Well, part of the issue is the issue of competency. So when the document you prepare is supposed to be your last will and testament,
right,
as Eric Clapton just said, it's your message to the world after you're gone. So first of all, before you can sign a will, you're supposed to be competent. And some people think that's pretty obvious. Well, there'll be lots of situations where I'll see somebody, and if the person doesn't even know what day of the week it is, or they have no clue and they'll only sign the document to satisfy their wife, technically I cannot take their signature.
And you from time to time actually have to say no.
I've had to do that, and it's been very hard where there may be a long-term client and and I'll have to say to the wife, look, I can't take his signature. Sometimes what I might have to do is get a medical opinion from the doctor.
Right.
And sometimes it depends on how drastic the document is. If it's a very simple document where they're leaving everything to each other and then half to each daughter, and there's only 2 kids, the level of competency may not be as high as where all of a sudden you want to leave everything to the neighbors. So the first key is I have to decide, and if you have a lawyer or a notary or any other professional, they have an obligation to make sure that person is competent when they sign the will.
Now, competent, and I hate to interrupt, but this is important stuff. Competent doesn't necessarily just mean a person's, for example, slipping into dementia. Competency could also refer to a person, say, recovering from a surgical procedure and so full of drugs, they don't know what day it is and wouldn't stand a chance.
And that's a very good point, because sometimes what happens, I might have to go to Lionsgate Hospital and I go see the person, I can't see them, and then I may be there a week later when they've recovered and they're fine. So, you know, if I've actually had to turn people away because they've intoxicated when they've come to my office. And I'll say, well, see you in a couple of days. And unfortunately, they were taking a taxi too. But so they have to understand what they're signing, when they're signing it. And sometimes the problem occurs not so much when it's been signed before a lawyer or a notary, because there's a whole idea that we're not going to risk our professional career on one will or power of attorney. It's more than maybe the neighbor gets a will off the internet and they get 2 neighbors to sign. So the person has to understand what they're signing. And then there's some special categories, which means that there may be a comprehension issue, but they're still competent. So the first case is if somebody doesn't speak English.
Oh, okay.
So we're fortunate enough in our office, we have people in our office who speak Farsi, Cantonese, Mandarin, and Italian, and we have access to both people who speak Spanish or German. So if somebody can only speak those languages, we'll have one of our staff members be the translator.
Sure, okay. So that removes that competency issue completely.
But the problem is let's say you have somebody coming in with someone who's their translator who speaks a language, you know, like Thai or something.
Right.
And you don't necessarily know that person's telling that person what, you know, they may be editing the translation, or, you know, you may say, do you like pizza? And they've actually told the person, that guy thinks you got a big hat or something like that.
Right, so when you use your in-house translators, you can be confident that they are interpreting word for word.
Because they're totally neutral.
Exactly.
There's nothing. And John can talk about the court issue of translators too.
Right.
But that's, so first of all, and then the second issue, if somebody's legally blind, sometimes they can, with these screens, can read a will with very high print. But either that, or else you can read through the will with them and they fully understand it, and then there's a special clause we say we read it to the person and they understand what they've said. So just because you cannot see doesn't mean you can't do a will.
Sure.
The other category too is if somebody's deaf. Again, hopefully you've got somebody who's a reliable sign reader who can do the translation, but they usually can read. And then if somebody's very weak, you can still have someone just sign an X of a will. That's still a valid signature.
In 2015, you can still make your mark.
You can still make your mark.
Interesting.
So those are things that just because they have some disabilities doesn't mean they're not competent. At this point, we have not accepted video documents, and whether the law may change in 5 or 10 or 15 years, that hasn't happened yet. But
by a video document, John, do you mean instead of preparing and presenting a written will, one reads the contents of the document to a video camera and that suffices as the will?
And that hasn't happened yet, but whether that will happen in 5, I mean, the technology is changing so quickly that we just don't know what to expect in the future. So, and now, as we talked in the last show, you can have these testamentary documents. They still have to be in writing, but whether they'll be on tape or not. But again, even then, you have to make sure the person was competent. And if they do a document like that without a witness, you're lacking evidence. Now, when someone signs a will, you have to have 2 witnesses, and the 2 witnesses are there to say, yes, that person signed it, and they knew what they were doing. They signed it. They were competent, and they did it freely and voluntarily without fear of intimidation.
Right. And John White, you've told us about a case in which, on a previous show, in which there was a blank form that the witnesses signed in advance. Oh, sure. Well, we know it's going to be, right? So here, sign here, and we'll fill in all the other stuff later. And that, of course, is that's so backwards, it's just not admissible, is it?
Well, that's just another example of why you should never sign a blank form.
Right.
Because you never know what's going to be put in above your signature that you're supposed to have agreed to.
Right.
Yeah, in that case, the will was invalid because these people hadn't witnessed the signature of the testator. They had signed in advance, as you say.
Right.
And so that was no good. I mean, the will was ultimately approved anyway, but that's a problem, as it is and should be with really any legal situation.
Right.
You just never do that.
And so now Dwayne's saying we need to take a break. And so let's do that now, because when we're talking about undue influence, now we've identified the matter of competence and all of the aspects of it in which you can be declared to be competent or not. There are a couple of other categories that play into undue influence, including something called fear of intimidation. And we'll deal with that when we return right here on The Law Show on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.